Hello and welcome to today's tutorial. Today's topic, we're going to cover directors and officers as well as EPLI, Employment Practice Liability Insurance. My name is Carly Rahm. I'm the marketing representative for Griffin Underwriting. We'll go over a brief introduction about Griffin Underwriting Services, otherwise known as GUS. I'll give an introduction about the product. We'll go over the insuring agreement, some vocabulary. We'll touch on details about directors and officers, employment practice liability, some markets, and then quoting instructions. As with each tutorial, there is a contact list should you have any questions or need any help at the end or at a later date. So Griffin Underwriting was founded in 1928. We still are family owned and operated by the Griffin family. We were one of the first surplus lines brokers in our region to be granted binding authority by the Lloyd's of London. We're very proud of that. We have just over 100 employees throughout 3 different offices in the Pacific Northwest. We can offer solutions for personal lines, commercial lines, brokerage, transportation, as well as surety. We've written over $95 million in premium to date, and we are licensed in all 50 states, including the District of Columbia. This allows us to work with agents nationwide. So we're going to go over directors and officers coverage. This particular type of coverage is designed to protect directors and officers of corporations, no matter if they're for-profit or non-profit, from losses arising out of alleged or actual breach of their duties. We're also going to touch on employment practice liability, EPLI. This provides coverage protection for an employer against claims made by their employees, former employees, potential employees. It also covers discrimination, age, sex, race, disability, etc., as well as wrongful termination of an employment, sexual harassment, and any other employment-related allegations. So we're going to address the following for both D&O as well as EPLI: the covered persons, covered organizations, the covered territory, covered damages, and then covered defense costs. When we're talking about covered persons, this usually includes the firm itself as well as the individuals within the organization while they act within the scope of their duties. So this can include the partners, principals, employees, as well as the directors. This also can cover persons no longer affiliated with the insured firms, but only for acts on their behalf of the insured. The third-party coverage, like for subcontractors, is usually available, but it's important that you should have a conversation with our underwriters if this is requested. This also can cover heirs, executors, and trustees, both for D&O as well as EPLI. When we're talking about covered organizations, it's usually coverage for the firm named on the, it is covered for the firm named on the declaration. Some forms offer coverage for predecessor firms, like a corporation or a partnership whose assets and liabilities are named insured and the majority successor of interest. There is not always automatic coverage in the form of new entities formed by the name insured, so you'll want to read those forms carefully. Understand what type of policy you are talking to your insured about. When we're talking about the covered territory, you want to look for unrestricted worldwide coverage. There is an exception. One example is coverage for wrongful acts requires both the wrongful act to be committed and the suit brought within the United States or its territories, possessions, or Canada. So again, this is another example of how you'll want to pay attention to that wording. When we're talking about covered damages, so this coverage is for damages or losses the insured becomes legally obligated to pay. This can either be through a judgment in the court of law or a settlement between the insurer and the claimant. When we're talking about punitive damages, these are court-imposed penalties. It's dependent on the carrier. Typically, these are excluded. There is an exception, like if a statute makes it legal to have or the most favorable venue wording is on the form. As far as covered damages go, it is depending on the form, but settlements can be made with or without the insured's consent. So again, I can't say this enough or stress this enough. Please pay attention to the wording for these types of policies. When we're talking about defense costs, it provides coverage for investigating, defending, as well as settling claims. It can include costs such as attorney's fees as well as court costs. The coverage can be written inside or outside the policy limit. and there can be a specific request necessary for defense outside the limit. It is completely dependent on the carrier as well as risk, but have that conversation with your insured. The defense is subject to a deductible if the deductible is listed on the policy form. If it's not listed, it is not subject to the deductible. And some companies offer policies that are defense only. So basic vocabulary, when we're talking about triggers, there's an occurrence versus claims made. Typically, these types of policies are written on a claims made form. There's prior acts coverage, extended reporting period, the standard of care, fiduciary liability, and wage and hour claims. So when we're talking about prior acts coverage, it's usually only provided when a claims made policy has been enforced immediately prior to the current claims made policy on a basis consent with the prior policy. This coverage is defined as covering acts that occurred between the retroactive date and the current policy date. Again, this is listed on the forms. Full prior acts coverage provides coverage for the entity's formation without a retroactive date. So you want to pay attention to if it's listed as full prior acts or prior acts. When we're talking about the extended reporting period, this is also can be called tail coverage. It provides protection for claims that are filed after a claims made policy has been non-renewed or canceled. There's a specific time, I think the maximum is 120 days, but again, you'll want to double check on your policy. This coverage is optional. It's typically recommended when an organization is required or goes out of business, or the decision has been made not to purchase insurance going forward. It is form dependent. It can be unilateral, only if the insured cancels or non-renews, or it can be written bilaterally if either the insured or the insurer decides to cancel or non-renew the policy. When we're talking about standard of care, there is a definition for negligence. The basic definition is it exists of a duty or obligation to conform to a standard of care. So what would the basic person do? With these types of policies, there's two different quote-unquote standards of care. We've got ordinary negligence. This is what a reasonable person would do and what their standards would be, or the professional negligence. The act must be within the same care as that of a reasonable member of the same profession. There is a causal connection between conduct and resulting of injury or damage, and then the standard of care also lists the subsequent damages. Fiduciary liability. This pays for the legal liability claims arising from alleged failure to follow Pension Reform Act of 1974. So the owners or officers that are making the decisions about their employees' 401k or other qualified plans are responsible for their actions. Under the ERISA Act of 74, fiduciaries can be held personally responsible or personally liable for losses to a benefit plan incurred as a result of their alleged errors, omissions, or breach of their fiduciary duties. What is this saying? This is saying that those who are making the decisions for their employees, if they are in breach of that contract and not doing their standard of care, their personal assets can be held liable. This is commonly included with a D&O package. When we're talking about wage and hour claims, it pays for damages resulting from employee misclassification, improper deductions, deceptive timekeeping. And we're seeing this come up quite a bit for employment practice liability. You'll see this a lot for those who are hourly basis, or their part of their compensation is tip splits, maybe overtime, that sort of thing. So when you're having a conversation with your insureds, if they are part of a board, if they are a director or an officer, essentially pointing out what their exposures are, this product sells itself. Their personal assets are at risk, not just for their company. There is a duty to defend. It protects cash flows and corporate assets. So most companies, they can't fund a claim without impacting their financial situation. And it safeguards the organization strategy. So if there is a claim arising, it helps to protect the organization. It helps to maintain focus so the organization can continue to move forward. It's just an overall great type of coverage to have. Here's a short list of some of our top classes that we write D&O and EPLI for. By all means, this is not a comprehensive list. This is just more to get your brains going in the direction of who to have conversations with. If you have someone who's asking about this particular type of coverage and they're not on this list, that does not mean that we don't necessarily do it. Give us a call or shoot us an email. More than likely, we can help you out. Some exposures for D&O: failure to perform duties, so conflicting personal interests, making board decisions without adequate information, engaging in personal activities, kind of crossing those lines, and then failure to perform according to the statutes in terms of the articles. The IRS is increasing its oversight of tax-exempt entities, so if you have a customer who has a nonprofit organization, every director and officer needs this type of coverage, but the IRS is really cracking down on those nonprofits. So have this conversation with your insureds. The limits do apply per claim. There is an aggregate limit, which is the maximum policy will pay during a policy period. If a deductible is listed on the declaration, it does apply per claim. It does apply to indemnify the SIR as well as defense, but again, it's written out on the policy. You'll want to pay attention to that wording. Common exclusions, it's important to say that a lot of the common exclusions can be endorsed or covered through other policies. But here are a few: unfair business practices, against public policy otherwise uninsurable claims, business risks within the insured's control, breach of contract, failure to procure and maintain insurance, dishonesty, criminal or fraudulent acts, BI, PD, or personal injury. Again, a lot of these can be endorsed back on or covered under a different policy. Here's just a couple quick stats. Again, just trying to give you some tools in your toolbox to have conversations with your insureds. An employer is more likely to have an EPLI claim than a general liability or property loss claim. Fewer than 25% of employees currently carry EPLI coverage. There are over 27 million small businesses in the U.S. with under 500 employees and that are not publicly traded. I always tell agents all the time, if they have customers who have even one employee, please be having this conversation for EPLI coverage. It's super important. It's a quick quote and a really competitive pricing. And then an employment-related claim without merit, basically meaning that an employee can file a claim and there's really nothing behind the actual claim. It still will cost that employer anywhere from $10,000 to $20,000 just to defend themselves when they've done nothing wrong. So costly claims, really competitive premiums for coverage, and like I said, a very quick turn time. So have these conversations with your insureds. Here's again another list of some of the top classes that we write EPLI coverage for. Again, not comprehensive, but have those conversations. Common exposures for EPLI: Fair Labor Standards Act, Equal Pay Act, Title 12 Civil Rights, Age Discrimination, Americans with Disabilities Act, Family Medical Leave Act, Uniform Service Act, and then wage and hour claims. I think we're all pretty familiar with these. You see them listed or talked about all the time in any workforce. It does not matter. Again, these are common exposures for this type of coverage. Any business owner is going to be facing these. There's also the wrongful termination, sexual workplace harassment with the Me Too movement everywhere. This is kind of a hot button, if you will. And then retaliation against employees. Again, it's just having that conversation with your insured, explaining what their exposures are, even if they have a very small staff, the exposure is there, and letting them know, what sort of coverage you're able to help them get. As far as coverages go, we do offer these at a minimum premium of $350. Again, we can quote these really quickly. We can offer defense costs outside the limit, third-party discrimination as well as harassment, internet email coverage, full Priors Act coverage versus retro date coverage, punitive damage endorsement, wage and hour endorsement, workplace violence, and then coverage available for independent contractors. We have a lot of capabilities. Again, if you're not sure exactly what is needed, or if you have a customer that you're not sure if it falls within this category, but you want to have a conversation about EPLI coverage, please reach out to our underwriters. We're happy to help. Common exclusions for EPLI. Typically the exclusions are covered elsewhere under different policies. So BI and PD, the ERISA benefits, workers' compensation, and unemployment benefits. For uninsurable, we've got the criminal, fraudulent, or dishonest conduct. And then for the business risk, Fair Labor Standards Act, liability assumed under contract, and the National Labor Retaliation Act. So again, a lot of the common exclusions can be covered under a different policy. In order to quote directors and officers, we do need the completed applications. Typically, most applications are on our website, www.gogus.com. If you can't find what you're looking for, reach out to us. We'll get you the necessary application. A lot of times our underwriters, per carrier instructions, we need a copy of their financials, the most recent income statement. We typically need a business plan and or a copy of their resume as well. When we're talking about employment practice liability, like I said before, we can get a quote to you really fast for this. We do need the completed app, also on our website. For those larger firms, we might need a copy of the employee handbook and their financials. A lot of times we can give an indication with a name, location, number of employees, as well as a classification code. If you have any questions at any time, please don't hesitate to reach out to us. That's why we're here. We are happy to help. We want to help you. We want to make sure business doesn't walk out your door. For those Allstate agents, email or call us, csr@gogus.com or 844-859-1766. For those non-Allstate or independent agents, info@gogus.com, 800-562-8095. Again, my name is Carly Rahm. I'm the marketing representative. I just want to say thanks so much for taking the time to go through this tutorial with me. We love working with you. We appreciate it. Thank you so much. We look forward to working with you more in the future. Have a wonderful day.